Okay, good morning, good evening, good afternoon, everyone, wherever you are. This is a closed session following the June 2022 International Conference that took place in Yerevan, Armenia, and the substance of what was discussed then. However, unfortunately, given the recent attacks in September, we are going to ask a couple of questions as to what happened last month. So we are very grateful to our speakers here today for agreeing to do this, after the conference, and we appreciate their time. They're in 3 different time zones, so they've got a lot of things going on. One other thing to keep in mind, this is a closed session, as I stated earlier, but if anybody has a burning question, and if we have time at the end, we can certainly take a question or two. You could just email it to info@cftjustice.org. And I will give you, I'll tell you around approximately what time you can submit the last question, if there are any, and again, if there is any time. So with that, I want to actually introduce our speakers again. We have Yelena Ambartsumian. She is General Counsel of ZUVIC, an infrastructure and environmental engineering firm based in Connecticut. She is also the co-founder of Kamijan, an Armenian lifestyle brand, and consults on art and IP law matters. So welcome, Yelena. And then next we have Alexander Herman. He is director of the UK-based Institute of Art and Law. He has written, taught, and presented on a variety of topics related to art and cultural heritage. He has a book out, Restitution. I love holding it because it's such a happy color. And his writing has frequently appeared in the art newspaper. He has been quoted widely in the Atlantic, Guardian, Telegraph, and Bloomberg. Prior to joining the Institute in London, he also worked for the leading art law barrister Norman Palmer in London and practiced in Montreal. He is also program director of the Art, Business, and Law LLM at the Center for Commercial Law Studies, Queen Mary University of London. So welcome, Alexander, joining us from across the ocean. Next, we have Simon Maghakyan. He is based in Denver. He is an investigative researcher and community builder whose civic tenure includes nonpartisan service at Colorado's legislature, human rights campaigning at Amnesty International, and organizing with Armenian American organizations. Academically, he is a lecturer as well. And one really cool thing, I mean, like Alexander and Yelena, he has been published in many publications, but one really cool thing, that tidbit that I wanted to add, is that he has been quoted in the John with his research in Nakhichevan. So welcome, Simon, and we're so happy to have you here. My name is Arsine Grigoryan, and I will be moderating this session. During the day, I am a class action litigator based in Los Angeles, and I'm one of the founding members of the Center for Truth and Justice. So with that, I just want to dive right into our questions. So the first question I am going to pose to Simon. It says, given the many issues with law and sovereignty, what is then the evidence regarding the status of cultural sites in Artsakh today?
Thanks so much for that question, and thank you for the invitation, Arsine, and to the whole team, and to my colleagues. So I'll talk about a few efforts that I am aware of. Obviously, we would all love to see an international by the organization in charge of global heritage, which is UNESCO, but that is an organization that's often run by states and not with a lot of power to enforce its own rules. So Azerbaijan is not interested in allowing on-the-ground observers in parts of Nagorno-Karabakh that are under its control, but also doing everything under its power to ensure that there's also no international access to Armenian/Russian peacekeeping controlled Nagorno-Karabakh. So that leaves with very few options, but thankfully in this day we have access to satellites, and an organization called Caucasus Heritage Watch has been doing amazing work of monitoring close to 300 sites and giving several reports each year in documentation. The last thing came out on September 12 or 13, morning of the 12th US time, which showed that another church has been razed to the ground in the occupied Hadrut region. One reason particular not yet much coverage, just hours after that report came out, Azerbaijan launched the September 13-14 invasion of Armenia, and so that kind of got buried in the news. But outside Caucasus, where Heritage watches satellite investigative efforts, I've seen some occasional reporting on that, digital forensics by organizations like the Digital Lab at the Atlantic Council, etc. I do want to, before talking about non-satellite mechanism, I do want to kind of give a very brief overview of the use of satellite technologies or geospatial technologies. So this became available to archaeologists in the 70s, and it's not a brand new technology. So with for about when it comes to documentation of cultural crime or heritage crime, one of the first pioneer investigations was by the American Association for the Advancement of Science, in collaboration with me at the time, which was into the destruction of Julfa Cemetery. This was in 2010. And right after that, we had destruction by ISIS and conflict-related looting, but also not conflict-related looting in places like Egypt and South America and Central America. I mean, those heritage crimes are also being monitored and often documented by satellites. However, satellites have their challenges. When there is clouds, you are not unable to document what's going on. So if Azerbaijan, let's say, were to polish out Armenian inscriptions, they could do it on a cloudy day, and we may never find out about it if we're just relying on satellites.
And
now sorry, go ahead.
No, go ahead.
I just wanted to mention a couple of other methodologies, because satellites are not the only way of monitoring cultural sites. So there is an organization based in Yerevan and Stepanakert called Monument Watch, where they use a multidisciplinary approach of monitoring what's going on. Some of the monuments can be seen given their geographical terrain, and they do observations, and they monitor Azerbaijan's media, etc. So there is an organization as well that I recommend people looking into. Another one is what I call is visual crowdsourcing, which I also utilize in my research into Azerbaijan's erasure of Nakhichevan's past, and that's basically which is very time consuming, is gathering every information you can find in social media, in news outlets that are showing videos and photos of cultural sites, and of course an average Azerbaijani is not allowed to go to the Armenian sites, but there's often propaganda delegations like the Udi minority propaganda pilgrimages, Darivang and other, truly very helpful in documenting some acts of vandalism we've observed so far. And then finally, I wanted to mention that Azerbaijan's own statements are also an important part of documenting of what's going on, their intentions and their treatment of Armenian monuments. This has been widely covered. Just wanted to mention that sometimes this is not only good for documentation, but also for litigation. That famous denial of Nakhichevan's Armenian past that was in response to one of my investigative pieces that Azerbaijan's ambassador put out was in the ICJ lawsuit, as you mentioned. So sometimes Azerbaijan does us favors unwillingly. That's all I'd say about the subject.
Thank you. So it sounds like what you're saying, that while we have the satellite imagery option, it does come with limitations, and we're not always going to get, unfortunately, the full picture there. All right. And with that, Yelena, I'm going to pose the next question to you. Does UNESCO have an obligation to take action under the 1972 convention?
Hi, thank you, Arsine. Thank you also to CFTJ for inviting us all back, and congratulations on your recent gala. So does UNESCO have an obligation under the 1972 convention? There's a short answer and a long answer. The short answer is no. And the long answer I'm going to give just for more exploratory purposes. So the 1972 UNESCO Convention on Natural Heritage it's something that also establishes the World Heritage List, and it safeguards and provides funding for cultural property of outstanding universal value, and it applies during peacetime. So states that are party to the convention have obligations to it. And again, this is something we talked about last summer. It only inherently applies to recognized UN member states. So Armenia and Azerbaijan, but not to Artsakh. Each state that's party to the convention has a duty to identify, protect, conserve, and transmit to future generations the cultural and natural heritage that it has situated on its territory. And that heritage is defined as monuments, groups of buildings, and sites that are of outstanding universal value from the point of view of history, art, and science. So consequently, a site's inclusion on the UNESCO World Heritage List requires the nomination by a country in which that site is located. So for example, Artsakh would not be able to nominate Ganzasar or Gaziantep to the World Heritage List because Artsakh is not a recognized UN member state that could be party to the convention. Armenia has nominated several sites, including Ichmeadzin and the monastic complexes of Gehard, Hakhpat, and Sanahin. But it hasn't nominated similar religious sites located within the territory of Nagorno-Karabakh, Artsakh. And I would also note that there's a tentative list that states have before they submit for inclusion onto the World Heritage List. They first maintain a tentative list of sites. And on that tentative list, Armenia has several, including Noravank and Tatev. And I mention those two because Noravank is close to Armenia's western border with Azerbaijan through Nakhichevan, and Tatev being in Sunik, which Azerbaijan has very openly claimed that it would like to occupy the Sunik region. So I think those two would be a priority for future inclusion onto the World Heritage List to move those off of the tentative list. Azerbaijan has proposed a number of its own sites for inclusion on the World Heritage List. On their tentative list, they have a fortress in Shushi in Nagorno-Karabakh. They have a mausoleum in Nakhichevan, but it hasn't nominated or placed on its tentative list any of the Armenian monasteries in Nagorno-Karabakh and Artsakh, even though Azerbaijan claims that it regards those as part of its Caucasian Albanian heritage. So nominating Armenian sites or sites in Artsakh in general is a complicated prospect. First, as a matter of practical significance, the World Heritage List gives the state in which the cultural property is located the duty to protect, maintain, and upkeep that cultural site, which Azerbaijan currently can't do if it doesn't have control over, the specific regions where that site is located. And second, although there are no penalties for violating the 1972 UNESCO Convention, because again, it's something also that applies during a time of peace, customary international law prohibits military attacks on cultural property of great importance to the cultural heritage of mankind. So that would necessarily include a site that's on the World Heritage List that Azerbaijan has designated as outstanding universal significance. So this is also why I mentioned that Noravank and Tatev should be inscribed, hopefully, on the World Heritage List soon. So that's the long answer. Otherwise, are there penalties under the 1972 UNESCO Convention for destroying, your own heritage? I mean, by having a World Heritage site in your country, you get to apply for certain grants and funding to safeguard and upkeep these sites. And if you destroy them, you lose the funding. So that's why people say that UNESCO has no teeth.
Thank you, Yelena. And I'm really glad you mentioned Tatev and Noravank, because, you know, we do sort of have our eye on them because they have their eye on them, and it's just sort of been the next frontier that they want to go to. So I'm glad you mentioned that. Just a really quick follow-up, if I may. You know, you mentioned that Azerbaijan, even though they're claiming certain Armenian monasteries and whatnot as Caucasian Albanian, don't you think it adds to our credibility, the fact that they're not submitting those sites if they're claiming it?
So, I mean, in terms of, you know, our credibility or the credibility for Armenian documents, you know, both optically and optically and legally, there's really no comparison. But it's really similar to how, you know, well, what credibility is there in saying that these sites are Caucasian Albanian and then destroying them? Azerbaijan claimed that all the cultural heritage in Nakhchivan was Caucasian Albanian, and that didn't stop it from destroying, you know, I think it was confirmed by Caucasus Heritage Watch, 108 monasteries, you know, and Hachkars. So yes, it adds to the credibility, but like, what do you actually do with that? How does that actually push anything forward? I'm not so sure. That's kind of a bigger discussion.
Okay, thank you. Next question goes to Alexander. How would you establish title to certain cultural heritage objects or sites? Oh. I don't know, maybe that was, I don't know what happened. How would you establish title to certain cultural heritage objects or sites that are not privately owned? In a similar vein, who would have standing to bring such claims?
Well, thank you, Arsine, and thank you very much to the Center for Truth and Justice for inviting me back. I guess I didn't do that badly. If you're inviting me back, it's not a bad sign.
You're great.
Obviously, I'm not an expert in the conflict itself. My area, of course, as you mentioned, is on restitution and art and cultural property law, and I'm always very interested in the international legal aspects of these kinds of situations where cultural heritage is at risk, and in some cases has been damaged or destroyed. So it's an interesting question, Arsine, about title. So, I mean, this would arise if, say, material left a territory and then ended up in another jurisdiction, potentially on the art market, maybe the black market, or what they call the gray market, which is sort of not the black market, but obviously not the fully legitimate art market, or indeed just people transporting material out of the jurisdiction elsewhere, not necessarily for the purposes of sale, but maybe just as pieces that they can display in their private collections. There's a long history, and thank you for plugging my book, Arsine, so I guess I don't have to, but there is a long history, which I try to cover in the book, of places of origin. I'll use that term in a general sense, trying to recover items of cultural heritage that have left their territory and that have ended up elsewhere, usually in the Western art market or in museums in the West. And there are several avenues that these places can take to try to recover property. It's usually quite difficult to do so strictly under international conventions. There's a confusingly closely related UNESCO convention, not the 1972 World Heritage Convention that we heard about from Yelena, but the 1970 convention. It has a very long name, and I won't bore you with it, but it's the convention that deals with the illicit trade in cultural property. The problem with that convention is it doesn't have a lot of teeth, which is a bit of a similar theme when it comes to UNESCO instruments internationally. But it's actually quite an important yardstick, because it establishes 1970 as an important date, meaning that anyone legitimately trying to acquire cultural property that came out of its place of origin after 1970 should have full provenance and full documentation. And certainly major museums would abide by that, or would at least try to abide by that. So you could at least hope that the ethical standards that are established by things like the 1970 UNESCO Convention are sufficient to ensure that if any material does come out of the territory, that it wouldn't end up on the legitimate art market, and certainly wouldn't end up in the collection of a museum. Now, what can be done if you locate material in another jurisdiction to try to recover it? Usually the best sort of avenue that might be available is to bring a civil claim through the civil courts, which obviously you know a lot about in California. But there have been examples of that taking place. And one particular case from 1990, I mean, it doesn't involve Armenian heritage, but it involves 4 beautiful Byzantine mosaics that had been looted from a church, a Greek Orthodox church in northern Cyprus after the Turkish invasion. And these pieces had been taken out by looters in the 70s, ended up on the, what I call black market, sort of the gray market, bought in Geneva by an American art dealer, who then promptly brought them to her gallery in Indiana, of all places. And it was discovered that these items had been taken from a church in northern Cyprus. And the actual claimant in that case was the autocephalous Greek Orthodox Church of Cyprus, which was kind of umbrella body of all in Cyprus, I suppose you could say. And they brought the claim, and one of the co-plaintiffs was the Republic of Cyprus, and they were allowed to bring that claim, and they succeeded. They were able to recover it. I mean, there are all sorts of technical questions about whether it was a good faith purchase, what the laws of jurisdiction where the dealer had bought the pieces, what it says about title and whether title can pass in that sort of situation. So there were a lot of technicalities in that decision, but I just use it as an example, even though it's over 30 years ago. It shows you that there can be these kinds of, in a sense, civil suits where not just a state of origin, because obviously in our situation that's a little difficult, but a church organization was able to bring a claim successfully and to recover those mosaics, which eventually were returned to Nicosia, not to the churches, because they were still in occupied northern Cyprus. So that's another option if that sort of thing happens. Obviously, it's costly. Arsine and Yelena, you can tell us about how much the cost would be for these lawsuits. Very expensive, and it would take years. Not ideal. A carrot and there's a stick, and so if the carrot is the ethical rules that I talked about, inspired by the 1970 UNESCO Convention, the stick, I suppose, would be the threat of litigation.
Alexander, thank you for your response. I had a thought because I'm thinking about the ICJ decision and how one of the things in the cultural heritage section had to do with not just churches, but also cemeteries and landmarks. And we've seen destruction of tombstones and grave sites of people, like the civilians' family members. So I don't know if you've ever seen any, I mean, maybe it's sort of, I don't think it's a unique case, but I don't know if you've ever seen any lawsuits pertaining to something like that, and whether it would be the family that has, as the plaintiff, because I mean, they're injured, or it would be a government or somebody else having to be involved to bring a lawsuit. Have you seen anything like that in your work? Or anybody here?
I don't know particular heritage damage or destruction, because probably those situations don't make it to court. But maybe from a human rights angle, there are some precedents where that sort of thing has happened. I mean, there have been claims brought in the U.S. courts about, terrorist attacks in Israel, for example, brought by survivors attacks or their family members. They've succeeded to a certain extent, as far as I understand, in U.S. courts. So, I mean, maybe that's some kind of guide or model. I'm not sure.
All right, thank you. Simon, I'm going to turn to you again. So I believe one of the things you discussed in the summertime was, sort of a remedy or solution. And one of the things you said, depoliticize sacred sites. So what can people do to do that, and what can governments do to depoliticize sacred sites and cultures, such that it's not exclusively to a group of people, but it's for the enjoyment of everyone?
Thank you, Arsine, for that question. If I'm allowed to make just a general observation about the topic, which probably goes without saying, but a lot of times why we're struggling with applying international law to Azerbaijan, to Nagorno-Karabakh, to Armenian survival, that the assumption is that the state sovereign acts in good faith. So none of the laws that were being written were thinking that, Azerbaijan is going to destroy the heritage of Nakhchivan, which is under its internationally recognized control. When the laws were written, people thought it was going to be invading or terrorist groups or this or that. We have this huge challenge, and that's where the ICJ case, I think, is brilliant by bringing in racial discrimination as the potential issue under which this a legal rethinking of this can be done. But let me go to the question of monuments. It's a diagnosis that sort of requires a historical overview of the Armenian-Azerbaijani conflict, but also understanding how this historical narrative battle started. And one way to think of this is look at the Soviet era, where called constituent republics of the Soviet Union, like Azerbaijan, like Armenia, like Georgia, to claim ownership of the history of the territories that they had control over. And this was an easy task for Armenians and Georgians, who have had very long presence, very proud of their monuments, but not so easy for Azerbaijan, that had to sort of justify this vast Christian heritage that exists on its territory, and even the Islamic heritage that's not just part of Turkic passages, is also, has to do with Iranians and so part of this competition over nationalization is what led to the revisionism. I know in the Armenian historiography we'll say, well, the revisionism is meant to sort of, get rid of Armenians in the long term, but I think we need to understand the roots of it and the nuances of that. And the other part of this that nationalization is that cultural identity in some ways was the only autonomy that Soviet republics had. And so oftentimes cultural autonomy was overcompensating for the lack of political autonomy. And so this is one of several reasons why cultural monuments have been so heavily politicized in this region. And we're now at a time and place where with a Azerbaijani historian or journalist, like, unless there are a few brave independent voices who typically live outside of Azerbaijan, it's hard to have conversations about cultural monuments and leave politics aside, because they have been indoctrinated or part of the indoctrinators that these monuments have nothing to do with Armenians. Therefore, there's no discussion to be held. But I want to emphasize something, and I'm going to get to the answer eventually. But I emphasize something, that this depoliticization has happened and hasn't really been a huge issue among ordinary Armenians and ordinary Azerbaijanis. And we see that in the many Azerbaijani cemeteries that still exist in Armenia. And we see it in the fact that when Nakhchivan's heritage was being erased from 1997 to 2006, there was very little, if any, popular support for the destruction against the Armenian monuments for a variety of reasons, but also because of this idea among ordinary people that you need to respect sacredness. But within political elites, that's not something that we have heard a lot. So one thing, and I mean, I don't know if I made a good enough case, but in March, I wrote in the Wall Street Journal about the role that Azerbaijan's religious leader and Armenia's religious leader can play in depoliticizing cultural sites by calling for pilgrimages. But I know you're asking what individuals can do, right? And that's a tough one, especially in the ways that we interact on social media. It's all about sort of being confrontational, etc. I think we can, as individuals, think of ourselves as having a duty toward monuments for their protection, when it comes to Armenian monuments, the most important thing is to ensure Armenian physical existence at those monuments. So some might see going out of your way to go on a pilgrimage to an Armenian monument. Obviously impossible to do it in Azerbaijan, but still possible to do it in Turkey, that ensuring the relationship, continuing the relationship that we have with our monuments endures. And in those processes, when there's interactions with local Kurds or Turks and maybe in the future Azerbaijanis, the idea that these are sacred sites to our people, that needs to be emphasized over sort of historical belonging at this point. I think that's the best way to overcome this politicization. But it also means being more generous on part of Armenians when it comes to Azerbaijanis and not mocking, the Azerbaijani historical connections with Islamic sites, right? The Blue Mosque in Yerevan, administratively, architecturally, it's Persian, right? But Azerbaijanis, I think most Azerbaijanis in good faith consider that part of their history as well. And we don't need to change history, but at the very least, we can acknowledge that that mosque is sacred to Azerbaijanis, and expect sort of the same mindset from Azerbaijan toward Armenia. But with this current regime in Azerbaijan, I don't think there is really much hope for any of this, because they thrive on conflict, they thrive on Armenophobia. So it's a really, really dangerous situation we're in, and I'm thankful for this discussion. I'm thankful for what your organization is doing, the ICJ case. There are things that are being done to try to minimize the damage. I have also heard that the Armenian Church, Echmiadzin, might down the line consider a lawsuit to claim a stewardship of Armenian monuments under Azerbaijan's control, which is an important stakeholder in this discussion. But I hope that in that process, they'll also find some commonalities with Azerbaijan's religious leaders to ensure that we're not just thinking of preventing dysfunction right now, that we are, have a common vision for respecting and preserving sacred sites in the region.
Thank you so much. And you said something that I'm going to use as a segue to swing back to Alexander here. You mentioned the SERD, and so the question here, Alexander, is you had mentioned that the Hague Convention does not have a strong dispute resolution, but that the SERD does. For those of you that don't know, I'm just going to give a quick plug-in. The SERD is the Convention on the Elimination for Racial Discrimination. And when Armenia brought that case against Azerbaijan, it used the SERD, and it also used it as part of cultural heritage. On August 8th, myself and a few of my colleagues, Amelia as well, we went to the UN and we presented before the SERD. And so back to this question, and I think this is important. Can you expand on what you said earlier regarding the Hague Convention versus the SERD, and why you think there has been many either little attempts or no successes when it comes to cultural heritage-related lawsuits under the SERD, and how you see the future evolving with respect to that?
Well, I think that the SERD hadn't been used in relation to cultural heritage issues because in some ways the SERD, as Simon was saying, I mean, it's more focused on questions of racial discrimination in the traditional sense, like lack of equality, for example, in relation to access to justice or clear instances of discrimination and the like. So it wasn't really initially made to focus on destruction or damage to cultural heritage. And that's what I think is quite unique and revolutionary about the judgment from the ICJ from last year. Now, the reason that I think the dispute ended up before the ICJ through the SERD is because, as you're saying, Arsine, that under another convention, which is quite an important one when it comes to protection of cultural property in the time of an armed conflict, whether that be an international armed conflict between two states or a non-international armed conflict like a civil war or a conflict within the territory of a single state. The Hague Convention from 1954 is a very important instrument. And it really is in terms of establishing standards, affecting military manuals, how militaries will operate is very much circumscribed by the Hague Convention. So they wouldn't target a religious site, for example, in almost every instance, unless it had become a military target. Just as an example, or they wouldn't allow troops to vandalize or to pillage a sacred site. So that's all found within the Hague Convention of 1954. Now, the problem with the Hague Convention is that it doesn't have the best dispute resolution mechanism. So if there is a dispute between two states, or potentially around the conflict within a single state, like the situation here, there isn't really much that can be done apart from using what are known as protecting powers. So it means that in the traditional sense, you'd have two states that are at war. One state thinks that the other state might have damaged some cultural property. They would go respectively to their protecting powers. So these would be neutral powers that essentially oversee those parties in the conflict. So, in the case of Armenia and Azerbaijan, that would be Russia and Turkey, respectively. And then through the protecting powers, you reach some kind of resolution. You make sure that the damage is, or the attacks are ceased, and that any damage is fixed, and that kind of thing. But it means that everyone has to cooperate, the two states, the protecting powers. You can also ask for UNESCO's assistance, but it's not a very binding sort of formula. So all that to say that it's a very complicated system. It's not actually used in practice very much. So as a result, there isn't really a way to get to the ICJ, the International Court of Justice, using the Hague Convention. Now, the other thing I should say just about Armenia and Azerbaijan is that neither of them have signed what's known as the optional protocol to the International Court of Justice in the ICJ's statute. The optional protocol would mean that if a state signs it, that they bind themselves to the ICJ and any judgment that the ICJ would render that affects them. If you haven't signed it, it means you have to then proactively agree to the ICJ's jurisdiction for a specific dispute, or you've signed a convention like the CERD that provides a mechanism of a recourse to the ICJ. And that's what happened here. It was through the CERD. Neither Armenia nor Azerbaijan are party to the optional protocol to the ICJ statute. So in a sense, the CERD was kind of the only vehicle that could get you to the ICJ in this way, because the Hague Convention one didn't work, and neither of these parties are signatories to the optional protocol. So I know that's a very technical answer, but that's basically how it ended up happening through the CERD in my view.
So I actually, we did have a few questions come in. So while I have a follow-up question to that, I think I'm going to move on for the sake of time. So I'm going to move back to Yelena now. So the question is, recent attacks on the de jure borders of Armenia, the obstacle of state sovereignty preventing any fact-finding missions wouldn't really be an issue. Do you see any other obstacles that may still come up?
Okay, so this is a wonderful question. So I think this question also alludes to what we saw happen with UNESCO's Second Protocol Committee, so Second Protocol to the 1954 Hague Convention. In December of 2020, the UNESCO Second Protocol Committee decided to send a mission of independent experts to take stock of the situation regarding cultural properties in and around Nagorno-Karabakh. That was their mandate. And even though the representatives of Armenia and Azerbaijan agreed in principle to this mission, Azerbaijan was approached several times thereafter by UNESCO and would not give them permission to enter. Meanwhile, this is happening for 2 years. Azerbaijan is giving excuses for why an independent mission can't be sent. Winter conditions, it's not safe, landmines, what have you. Meanwhile, Azerbaijan is able to invite the UN resident coordinator the regional coordinator, to Shushi to commemorate the 30th anniversary of Azerbaijan's UN membership in March of 2020. So you have the UN flag flying next to Azerbaijan's flag in Shushi, in the same city where Gaziantep's Cathedral, which is desecrated, is sitting, and which Azerbaijan is denying UNESCO permission to come inspect. So from this example, we see that the issue isn't so much about the de jure borders of Armenia or Azerbaijan, but really which country or who has de facto or effective control. I get a little uneasy when I hear practitioners or even organizations, not CFTJ Justice, but there, at least one other well-known Armenian legal organization, say things like territorial dispute when they refer to Artsakh, because it ignores, of course, that Artsakh isn't a territorial dispute, but a question of self-determination. It's Azerbaijan that's saying like territorial dispute, sovereignty, borders. And falling into this trap also ignores that Azerbaijan's biggest argument for the international community accepting Artsakh as part of its sovereign territory is the 2008 UN General Assembly resolution, which was a non-binding resolution with only 39 votes in favor, 7 votes against it actually, including by the US, France, India, and Russia, and over 100 abstentions. So it's really not about sovereignty, but about who has de facto control that is holding up this UNESCO mission. With respect to now like moving towards the borders of what, you know, the international community accepts as like the borders of Armenia, and Azerbaijan attacking that territory, occupying that territory, destroying cultural heritage in that territory. Well, can I see a situation where Azerbaijan occupies Karahunj, which if people aren't familiar, it's known as the Armenian Stonehenge. I saw it for the first time last summer. It was really remarkable. And it tells, and then occupies Karahunj, and then tells the UNESCO Second Protocol Committee that it's not safe to send a mission there because of landmines or shooting on the border or, you know, whatever other excuse they create. So yes, of course, I can see them doing that. Likely there would be more pressure in those circumstances from the international community and from large member states. But we also see how difficult it was to send independent EU monitors this past month to review ceasefire violations. And as far as I understand, you know, the scope of that mission, those monitors are on the territory of Armenia that is not occupied by Azerbaijani forces, and Azerbaijan really didn't want any, you know, monitors there. So I guess that's another way of saying that I don't think that the attacks being on the de jure borders of Armenia remove any obstacles when it comes to fact-finding missions being able to be sent to the area, because if there's territory that Azerbaijan occupies or is under their control, we know what their answer is about having any type of like good faith, independent mission being sent.
Okay, thank you. And I just, we actually had a question come in during this, and it had to do with what you, Karahunj, what you mentioned, the Armenian Stonehenge, which I have been to. It's amazing. And just really quickly, the question there was, can that be included in World Heritage, and what can we do? So I think you like kind of addressed this question. It's like you read this person's mind. So thank you. And then I'm gonna go back to Alexander here. Other than raising awareness, what can be done regarding punishing the perpetrators for vandalism, misappropriation, and what?
Yeah, it's an interesting question. I mean, in a sense, the practicalities of it relate to, you know, to go back to what Simon said at the very beginning about just being able to know what's happening on the ground, because I mean, you can't really punish perpetrators if you don't know who they are and what they did and when they did it. So it really relates to the facts and how you're able to demonstrate them if ever you need to prosecute people. Now, yeah, I mean, raising awareness sounds a bit ineffectual, I guess, compared to, say, prosecution, especially, you know, international criminal prosecution. I mean, one of the things I will say, it hasn't been mentioned so far, is that neither Armenia nor Azerbaijan are party to the Rome Statute, which established the International Criminal Court. Obviously, that would have given jurisdiction to the International Criminal Court in The Hague for prosecutions relating to damage or destruction, intentional damage or destruction of monuments that are used for religious or cultural purposes. We saw in 2016 a successful prosecution of that kind of war crime in Timbuktu, the Almaty case at the International Criminal Court. So there is precedent of that happening, and it also happened in the case of the war in the former Yugoslavia as well, and the prosecutions before the International Criminal Tribunal for Yugoslavia. So there is precedent where that's happened, but it's very difficult if the party, the state itself is not a subscriber to the Rome Statute or hasn't accepted the jurisdiction. The other thing I should mention, because it's always good, I think, to rely on those international instruments that are actually at play in the relevant situation. And Yelena mentioned the Hague Second Protocol Committee, and that's relevant because both Azerbaijan and Armenia are party to the Second Protocol to the Hague Convention. So I mentioned the Hague Convention already. It's an important international convention from 1954, protecting cultural property in armed conflict. The Second Protocol was created in 1999, largely in the aftermath of the conflict in the former Yugoslavia. So that was very much the impetus there. But what it did, amongst other things, was it established certain criminal offenses, international criminal offenses under the Second Protocol. And that included extensive destruction or appropriation of cultural property. And so parties to the Second Protocol, like Armenia and Azerbaijan, obviously would then have to create in their domestic law criminal offenses that reflect that offense under the Second Protocol to the Hague Convention. Now, I'm not sure how that's been done by Azerbaijan, for example, or by Armenia. I do know how it's been done by the UK, which is a country that I work in. And it's interesting to see because it is possible to have a broader jurisdiction for international criminal prosecution. So usually international criminal prosecution would relate to the nationality of the defendant or the territory on which the alleged crimes were committed. But actually, if the offense is the extensive destruction or appropriation of cultural property protected under the Hague Convention and the Second Protocol, then the jurisdiction for courts in other countries is much broader. So it could actually apply to an offender being present on the territory of any other state that's party to the Second Protocol. Now that seems very unlikely, obviously, but it just sort of expands the scope of what is legally possible in international criminal prosecution. So it might limit anyone who you knew who had committed any of these kinds of offenses. They would actually be quite limited in terms of where they could travel internationally, because they wouldn't be able to end up in a country that signed up to the Second Protocol, because they could potentially face criminal prosecution there, like in the UK, for example, which signed up to the protocol in 2017. So I know that sounds probably quite remote and far removed from the actual tragedies of what's happening on the ground today. But obviously this conflict is one that's going to live on for a long time, and there will be a chance, one hopes, in the future where those who've committed the worst atrocities are brought to justice, whether close to the region or sometimes far away from the region. So that's why I thought I'd mention that.
Thank you so much for that response. So it's 10 minutes left. And we have one question from the questions that came in from last summer, which was posed to Yelena. But before I go in there, Alexander, so in your book, you kind of talk about, I know we're talking primarily about sites, and a lot of your book has to do with artifacts and different things. And I think one of the things there that was discussed was the argument for and against it. And one of the things that was discussed was how sometimes, if a different well, to use your term, a place of origin, if a different object is not in its place of origin, it's for education purposes. And I know it's good to, everybody just loves to talk smack about the British Museum when it comes to this. But in that sense, it got me thinking about Ukraine and Armenia and everything that's going on. If certain objects are in different countries that are not involved in the conflict, in some ways they're protected. And so that's sort of an interesting thing. And I remember with Ukraine, there was an article about how they were trying to hide paintings and everything underground right when the war had started. So it's an interesting thing when, we try to keep things within the country of origin, but sometimes, unfortunately, they're safer outside whenever there's a war. So the last question is for Yelena, which is sort of similar to another question that was posed to her, but we had about several questions come in, so I'm just going to take them, whoever submitted them earliest. But so Yelena, the question for you is, the September 2022 attacks are of an international character. Does that status somehow elevate or make it easier to preserve, mitigate, and punish? And if so, how?
The answer is very short. So in terms of punish, I think Alexander has done a masterful job of explaining the Hague Convention and also sort of the limitations of being able to pursue an action under the 1954 Hague Convention and Second Protocol. One thing I would mention is that while the ICC, the International Criminal Court, isn't part of the UN, part of the United Nations, there is a way technically to get to the ICC by having the UN Security Council refer certain situations to the prosecutor of the ICC. So that gets me into my answer now of this question. Having this be of an international character, Armenia's sovereign borders being attacked by Azerbaijan, does that make it easier to preserve, punish, mitigate? I think the question was. So yes and no. I think a lot of these conventions that we discuss are really after the fact. So after the war, after the attacks, whether they be of an international or an internal armed conflict character. So I don't necessarily think it makes it any easier to help preserve or mitigate whatever Azerbaijan chooses to do during such an armed conflict. But in terms of punishing, there's another aspect of this that we haven't talked about, which is really, as lawyers, especially I think law students see like, oh, there's a convention, oh, there's a treaty, oh, there's a law. Okay, I can use this to make an argument. Yes, but there's also this huge political, case, political pressure that can be built, and which is really necessary. And I think, especially in terms of something like having the UN Security Council refer a matter to the ICC prosecutor general, that means that there's enough pressure from, important member states to have like this issue looked into and have, perpetrators brought to justice. So do I think having it be of an international character, the recent attacks, like, do I think that makes it any easier to preserve or mitigate cultural heritage destruction? Unfortunately, no, not directly, but I think indirectly it might be, easier for certain states, constituents in these states to really like call the attention of their representatives to these issues and say this is like a hard line for them, and then to use that political pressure and political diplomacy to then try to change the situation on the ground.
Okay, thank you all so much. I'm just going to take one question from the several that came in just by order of who was first. So the question is, and I'm going to pose it to all of you, whoever wants to take it. With respect to Google sending vehicles within the last week to scan the streets of Shushi and renaming both the streets and buildings that remain in the city, would this be considered destruction or falsification of Armenian cultural heritage?
So there's, I was thinking about this. There are also private companies that have been helping Azerbaijan redesign sushi. There have been companies that have like architectural drawings that are removing apartment blocks or have removed apartment blocks, which obviously makes it harder for people who are living there to later return to sushi if they could, because now they no longer have a home. So I think it's a wonderful question whether or not private companies are now aiding and abetting in crimes of ethnic cleansing. And I think that's a wonderful thing for the Republic of Armenia to consider and also to bring to the attention in the third briefing.
Okay, unless Simon and Alexander have anything to add. No? Okay, great. So we do have another, I don't know, should we take another question? Let's take another question. Okay, what actions can be brought against US and European corporations who conduct business in Azerbaijan? For instance, a construction company built a road in the newly occupied territories using materials from Armenian cemeteries and monuments. That sounds like corporate responsibility to me, but if anybody wants to take that question. I mean, I think this is more, I don't know if this was necessarily posed as a hypo or not, but I think this is falls in line with more of a corporate responsibility. And I suspect, and either of you can, correct me if I'm wrong, but I suspect this falls into corporate responsibility and maybe not so much in the cultural heritage side of things, but it could be tied into it as well. And if Alexander, Yelena, Simon, if any of you have seen something like this, let us know. But it seems like it's sort of a very narrow incident and very unique in this context.
But again, I think it's a great question to look into. And so it would depend on, okay, what country is that corporation located in? Italy, for example, Italian construction companies, for example. Okay, what are Italian laws that these corporations might be breaching? In the US and in Canada, I know there were lawsuits against US and Canadian technology companies that manufacture technology for drones, which were later used in Artsakh to target civilians. So I think it's a very important question that, again, the Republic of Armenia or like others should look into, because it's one thing that really hasn't been addressed very much. And I think, look, we complain about Azerbaijan, how it's able to get away with all of this, with impunity, but they're helped by not just other states, but they're helped by private actors. And so there has to be some type of responsibility for those private actors in aiding, and abetting Azerbaijan. What that responsibility looks like, what those mechanisms look like, I think depends on where those private actors are based, which countries, which national laws, and then how to, proceed within the courts in those jurisdictions to be able to hold those companies accountable.
I think that's a fair response. So I actually, we're out of time. And I want to thank three of you so much for agreeing to do this. And Alexander, I saw your article in the Art, Antiquity, and Law Journal, and I read it. It was great. It's kind of discussing the ICJ decision from December 2021, and we're all very excited to see how that plays out, especially in the cultural heritage context. But again, thank you all so much, and I appreciate everybody showing up for this session.
Thank you.
Thank you.
Thank you.